for us to get started with our next panel discussion. So if we can start to get to our seats again. So our next panel discussion is Let the Sun Shine In, the citizens' right to know and participate in government at all levels. I'm now going to turn it over to Moderator Jerry Loendorf, Convention Delegate from Helena, to lead this discussion.
Good afternoon. Could you kindly take your seats? Could we have the people in the rear come up to their seats, please? Thank you. This channel, or program, panel, I guess, deals with transparency in government, and we have 4 real experts here to discuss the provisions in the Constitution that concern transparency in government. And I'm going to introduce them first, and then we'll go into the program. First, we have on my far right, or left rather, don't know my right from my left, I'm so nervous, Chuck Johnson, who's a journalist from Helena, Montana. He's covered Montana politics for almost, I haven't introduced him yet. Chuck has covered Montana politics for almost 45 years. During his career, he reported on 22 legislative sessions, 7 governors, 9 U.S. senators, 10 U.S. representatives, in addition to countless other state legislators, elections, and policies. He's reported for the Associated Press on Montana's 1972 Constitutional Convention. In 1974, he began reporting for Lee Newspapers, the State Bureau in Helena, then at Great Falls for the Tribune Capital Bureau. And he was actually located in Helena when he did that, and he served as a bureau chief there from 1984 to 1992. From 1992 until 2015, he was bureau chief for Lee Newspapers, writing for 5 major newspapers in Montana. He retired in 2015, but came out of retirement to cover the 2017 session of the Montana legislature for the Bozeman Daily Chronicle. Johnson recently was awarded an honorary Doctorate of Humane Letters degree from Montana State University. MSU's president, Cruzada, said, "If we have any understanding of Montana's government and how it has impacted Montana's citizens over the course of nearly a half-century, it is largely thanks to Chuck, who felt a profound sense of duty to keep the public informed and to be a watchdog. We are deeply indebted to him for his service." MSU Vice President Tracy Ellig wrote that Johnson was, quote, "clearly recognized by other journalists, by legislative staff, by legislators themselves, and members of the executive branch as a walking institution of fairness who doggedly sought to inform citizens of Montana about how their democracy was working." Although he's retired, he currently serves as board president of the Montana Free Press, which is a nonprofit corporation. And he has also served in the past on the Montana Historical Society Board from 2015 to 2020, and from 1990 to 2016 on the Montana Freedom of Information Hotline, which is also a nonprofit association that assists citizens and the media to gain access to government. Chuck, you want to wave? Okay. To my immediate right is Peter Mike Meloy. He's a lawyer practicing in Helena, Montana. He's admitted to practice not only in all state and federal courts in Montana, but also the United States District Court for the District of Montana, the United States Court of Appeals for the Ninth Circuit, and the U.S. Supreme Court. Not many of us make it there. He has been a member of the Montana Trial Lawyers Association for approximately 45 years and served as its president. He is also a fellow of the International Society of Barristers, the American College of Trial Attorneys, and the American Board of Trial Advocates. He has an AV, which is a preeminent rating from Martindale and Hubble, and is listed in Best Lawyers in America. He also served in the Montana legislature in the late 1970s, where he participated in drafting and passing significant legislation, including the enactment of provisions of legislation implementing Article 2, Section 9, the right to know of the Montana Constitution, and he sponsored the bill creating the Montana Open Meeting Law. While he was there, he served as majority leader in his final 2 sessions after having served as majority whip in his first 2 sessions. He has numerous awards for journalism, service, advocacy, and I believe he's received every award the Montana Trial Lawyers Association has to give. In addition to all that, he somehow found time to teach constitutional law as an adjunct professor at Carroll College for 12 years and to coach as a head girls soccer coach at Helena High School, where, as you would expect, he won 2 state AA championships. Mike? Our next presenter is Elizabeth Kavala. She's an attorney from Missoula, focusing her practice on representing public and private school districts throughout the state of Montana, as well as the Montana High School Association. Elizabeth is a graduate of Boston College and the University of Montana School of Law. After clerking for a year, Elizabeth joined the Montana School Board Associations as a staff attorney. She rose to the general counsel position and remained with the Montana School Board Association until 2003, when she returned to Missoula in private practice. Elizabeth serves as counsel for school districts in all areas of employment and school law. She provides litigation defense to school districts and their employees in federal and state courts, before arbitrators and administrative agencies, relating to all aspects of school district operations. Elizabeth is admitted to practice before all Montana courts, the United States District Court, and the United States Court of Appeals for the Ninth Circuit. She is a member of the American Bar Association, a former board member of the National Council of School Attorneys, and is a former president of the school law section of the Montana State Bar. She has been selected by her peers for inclusion in Best Lawyers in America since 2014 for her areas of educational law and employment law, and she was named Best Employment Law Lawyer for the Missoula area in 2015 and 2019. Elizabeth? On my immediate left is Andrew Huff. Andrew's also an attorney specializing in Indian law, water law, and federal criminal law. He is an enrolled member of the Chippewa Cree tribe. He graduated from Harvard in 1991 and the University of Colorado School of Law in 1999. He served in the United States Peace Corps in Cameroon, West Africa, from 1993 to 1995. Mr. Huff's legal career has been varied, working in the nonprofit sector, the government sector, and in the private sector. Prior to his present legal practice, he was Chief Legal Counsel to Montana Governor Steve Bullock from 2013 to 2017, and an Assistant Attorney General for the state of Montana. Mr. Huff has responded to public records requests in that capacity. Mr. Huff lives in Helena, Montana with his wife Margaret and has a stepdaughter and a son. Andrew? How we'll divide things up today is I'll briefly introduce the subject, and then I'll call on Chuck to give us some background that goes back prior to pre-1972. He actually lived back then and can give us firsthand knowledge. And he'll also discuss the debate of these rights to transparency as it occurred at the convention. He'll be followed by Mike Meloy, who's going to discuss the legislation first that was needed to implement these constitutional provisions, and then he'll also talk about some of the court decisions and the right to participate as well as the right to know. Elizabeth? I'm 83 and my memory isn't great. You're going to tell me about?
I'm going to talk about the right to privacy and the right to know and how that works.
Yeah. Elizabeth is going to talk about the right of privacy, the right to know, and how that works. She'll get into the tensions between the two. And Andy's going to tell us about his experience in handling record requests from the viewpoint of counsel for the governor's office. So I'll briefly introduce the subject here, and let me do so by stating some facts you already know. Article 4 of the United States Constitution provides that the United States shall guarantee to every state in the Union a Republican form of government. Montana has always had a Republican form of government. The Constitution of 1889 created a Republican form of government. The Constitution of 1972, which we are celebrating today, did the same. As we all know, too, a Republican form of government is one in which the people govern through elections. We, the people, hold the powers of government, but elect officers to represent us and serve our interests. We, the people, are not the subjects of government. Rather, we're more like the owners. And over the years leading into 1972, we learned that transparency is essential to representative government. We need to be able to monitor whether our elected representatives, to be sure they are voting and otherwise acting in accordance with their campaign promises. Before 1972, it was difficult to determine for a voter to determine what his elected representative was doing with regard to their duties. A citizen often had no idea what actions his public servants were taking, or even if they were taking action. We can't really repeat this too often, that transparency is essential to government. Mischief is the companion of secrecy, and because of this, additional provisions were added to our Constitution that are in our Declaration of Rights. These additional provisions and the implementing legislation will be the subject of most of this panel's discussion today. The new provisions in the Declaration of Rights are Section 8 and Section 9 of Article 2. Section 8 is labeled the right of participation, and it provides the public has the right to expect government agencies to afford a reasonable opportunity for citizen participation in the operation of the agencies prior to final decision, as may be provided by law. That final phrase, as may be provided by law, indicates that legislative implementation is required and that the section is not self-executing. Section 9 of the Declaration of Rights is also designed to promote transparency. It provides no person be deprived of the right to examine documents or observe the deliberations of public bodies or agencies of government, except in such cases where the demands of individual privacy clearly exceed the merits of public disclosure. Section 9 is self-executing, that is, no legislation is required to give it effect. In conclusion, I would observe that transparency benefits everyone. It gives a voter a report card, a record by which to judge an incumbent's performance. A challenging candidate in election can take issue with the actual record of his opponent, and the actual record protects the incumbent from misrepresentations on his or her positions. Finally, the press benefits, which benefits us all. Frankly, we are too busy in our daily lives to adequately observe the operations of government. We depend on the press to do that and report the results to us. Although the press has always had the freedom to report, it did not always have access to the information. Since 1972, the press has had both freedom and access, and we are the beneficiaries thereof. Now I'm going to call on Chuck Johnson, and he's going to go into how things were in pre-1972 and into the debates over the right to participate and right to know. Chuck?
Thank you very much, Jerry. I liked your comments. Another way to put it was Justice Brandeis, who said sunshine is the best disinfectant. Before 1972, and I was going to talk about the legislature, but Bob Brown did an able job of talking about how it was. It varied by town, by school board, by city council or commission. Some boards were open, some weren't. The most notorious were probably county commissioners. If they had a hot button issue, they'd adjourn, and the three of them would go down to the nearest diner and make a decision without anyone watching them. School boards did that sometimes. I covered some school boards that seemed like everything was predetermined, and later found out that, yeah, they would meet at one of the trustees' houses beforehand and talk it all out. That's really not what's intended. So I think one of the big reasons the convention was called was to open up government at all levels. A case that I was a senior in high school, and I remember reading about this one. How many of you seen the old state prison on Main Street in Deer Lodge? I think the state moved out of it in the late 70s. It's still used occasionally for movies if they want to show a dungeon-like prison. There was an inmate named Larry Cheadle who died in what they called the hole in 1966. The hole was where they put prisoners that were deemed troublemakers or difficult to deal with. They were in this awful part of the prison. They were given 2 buckets, one had water in it. They got a meal thrown in and a hot meal every 3rd day, and they saw a doctor every 10 days. He died in that prison, and the reporters at the time had a hard time finding out what happened because of state laws at the time. And it took a lawsuit filed by his family to open up the books and the records, and he finally his family finally got some answers about what had happened. And we don't have a hole in the Montana state prison now that I'm aware of, and lots of states did this. The prisoners that were causing trouble, send them down there for a week. They'll learn how to behave better. So I think a reason that this convention was called really was in reaction to things like this. At the convention, Dorothy Eck was the sponsor, the main sponsor of the Right to Know section. It went to committee and was kind of sailing through smoothly, got out of committee. It was coming to the floor for debate. And the newspapers of the state kind of got wind of it. They were asleep at the switch, basically. And a professor at the University of Montana School of Journalism named Bob McGiffert, who taught journalism law, saw this and became alarmed. And Bob wrote a letter to the delegates saying, if anything, it would make things worse. And he said it would allow the legislature to protect the confidentiality of specific matters. And he thought it was just a poor form of doing things. And that prompted newspapers to react accordingly. And the Billings Gazette publisher, a guy named Strand Hillebue, ordered up a front page editorial, "The Right to Conceal." He said, "It is rare that the Gazette places an editorial on page one, but we feel it's in the public's right to know. The public's right to know is vitally important if our democracy is to retain its strength." And he said, but as the article now stands, it would not be surprising if the public found it could not, in good conscience, vote for a constitution. So it's a threat, kind of. Well, the delegates reacted accordingly. They didn't like being threatened. And this editorial got picked up by a lot of places. And there were great debates on the floor whether to take this right out entirely, whether to amend it, give the legislature the power to do this. And a long debate happened. And another thing with the press is there was a guy named Bob Miller who headed the Montana Press Association, predecessor to the Montana Newspaper Association. He had press pass on the floor and was covering it for the weekly papers. He was also lobbying delegates against this provision. Total violation of ethics up here. So the press did not distinguish itself. Long debates. What do we do? Do we get rid of it altogether? That was proposed. That failed. In the end, Leo Graybill, who didn't speak often on the floor, said, "I've listened carefully to the debate, and I agree with many of the people who have spoken, but there are some things that I think we need to point out." He talks about the importance of it being in the Bill of Rights. Now, I'm concerned that because, as I understand, that the newspaper lawyer had something to do with this. When we're done with that, what have we done here? Suppose the newspapers say nothing's secret. Is the legislature says nothing's secret. Is the newspaper industry going to be happy? Yes, but what about the people? Suppose the legislature repeals its current statute some week or some year, and they say everything's secret. Have we protected the rights of the press or the people to know? We are giving up the right of the people to have us determine this matter right here. And he says, I'd like to, he goes into a long list, but he said, now you know the legislature as well as I do. They're not going to do that in one line. There's going to be a long list of different things that are secret. They're going to have the same trouble we're going to have by putting all this in statute. They said the legislature can make a long list, what's closed, what's open. He said, who's the person that's going to interpret the legislature's language? It ain't going to be the courts. It's going to be the agency. So the more language you give the agency to work with, the less to know there's going to be left, because they're going to interpret right out the window. So if the press really wants to lock this state up, just let them have the legislature pass a nice, long-as-your-arm statute about what's secret, and everything will be secret by the time an agency or agency head or the agency lawyer gets his hand on it and advises whether people can come to the meeting or whether the papers can be shown to the press. I don't think the press has thought this thing through enough. Well, anyway, he said, keep it as it was written, and that eventually passed. And the difficulty the delegates had is they mistrusted the press after this episode as much as they mistrusted the legislature. So who did they decide should make the decision? The courts. So it's very plain and simple in the language, although that except for provision has created a ton of litigation that Mike can talk about, and Elizabeth and Andrew. But I've always felt it was a pretty good provision. The courts have not been as sympathetic in recent years as they were early on, and that's been troublesome for a lot of reasons for the media, and I think some other people like it that way. But anyway, it's a difficult section with no easy answers, but I think in the end it's been an improvement, and we hope that we'll get some more good decisions. Mike won a case a couple weeks ago against the PSC at the district court level, in which the Billings Gazette had a reporter that was asking for documents at the PSC and was told no, we'll have to have someone review them for you before you can get hold of them at a cost of $31,000, and that got kind of laughed at by the district judge here. Now it'll undoubtedly go to the Supreme Court. I'll be anxious to see what happens. Thank you.
Thank you, Chuck. Next, we'll have Mike talk to us about the legislation that was passed to implement these rights of transparency, and also he's going to talk about the right to participate in government operations. Mike?
I grew up 2 blocks from this building, spent my younger years running around the hallways, but my most memorable events occurred right here in this chamber. So I have really fond feelings for not only this chamber, but the work that was done in 1972 and in the first 10 years after the Constitution was ratified, what the legislature did here. I took, in September of 1971, I took the bar exam here, and I got hired by Francis Bardenover, who sat in that chair right there, who was my mentor and Dan Kemis's mentor, to be the Director of Legal Services for the Montana Legislative Council. That was my first job as a lawyer. And I was the only lawyer, so I don't know why I had such a fancy title, but it put me into a venue that was almost like a perfect storm of wonderful, marvelous things. My first job was to watch you folks draft a new Constitution. And not only did I have good relationships with the young, bright research staff that the Constitutional Convention had, but I also actually helped some of the delegates with writing provisions, delegate proposals that had to do mostly with the legislative branch. I don't know why they thought I knew anything about the legislative branch. And I don't know how many drafts of Bob Kelleher's Parliament proposal that I did. I probably did 10 versions of that. Helped write part of the unicameral provision that was rejected by the voters. So my work here wasn't as successful as yours, but it was an incredible experience, and I would sneak up in the gallery and watch this marvelous group of Montanans work together to create this incredible document, and also get a chance to listen to probably the best orator I've ever heard in Wade DeHood, who, when he stood up, everybody listened. After you did your work, and managed to persuade the voters to pass the Constitution. All of the resulting work that was created by this new Constitution got shifted downstairs to the Legislative Council, and I was the only lawyer. And so four things happened. The first thing was I had to hire a group of lawyers who could draft implementing legislation. We also had to completely revise the legislative rules. The old rules were just absolutely abominable, and it was the sense of the Constitutional Convention that the legislature should be completely open. So we had to change rules related to how conference committees acted, how notice was given, how votes were taken, how they were recorded. Part of the task that we had was a practical one. Prior to 1972, when a bill was prepared, it was typed. And then the typed bill was sent to Fred Negley down at State Publishing Company, who published the actual bill. And that was fine, because when it came back up, it was a nice, clean bill that could be read by the legislators. The problem was that it was impossible for the public to get their hands on those bills. So in 1973, we created a system of bill drafting that permitted us to have all the statutes loaded into a computer, and we could actually print them, prepare the bills from the actual statute if it was going to be amended. We had the statute online. We could print in-house and have available right away copies of bills. We also changed the voting system such that it was possible to record every vote and to keep track of both committee minutes and votes in committees, as well as conference committees. When a new group of legislators came in 1973, many of them, I would say most of them, weren't familiar with the old way, so all of these new rules were fine with them. They didn't see that anything changed, and they were willing to keep their committee meetings open and vote in public. The conference committees generally tried to notify people when they were having a meeting, and I think in 73 and 74, the first of the only time that the legislature in Montana has met in an even-numbered year, was following the precepts that you adopted in Article 5 of your Constitution. We also had to implement all of the changes that you made, because it affected almost every statute on books. And after the 1973 session, we formed a number of committees whose task it was to examine each constitutional provision and recommend legislation to implement various aspects of the Constitution. I happened to be interested. I thought the most significant provision that you adopted in terms of maintaining a viable democracy in Montana was the right to know. So I sort of took an interest in that, and I did I did the study and prepared the implementing legislation. As Jerry explained to you, Article 2, Section 9, the right to know, is self-executing. So what is the legislature doing messing around with it? Well, the problem was that we had statutes on the books that permitted meeting holders, public bodies, to close meetings for a whole laundry list of reasons. And they had to be changed because the only way a meeting could be closed under your new provision was if the demands of individual privacy clearly exceeded the merits of public disclosure. So we had to amend the existing open meetings law to accommodate the new language. For records, there were 48 separate statutes that made certain records totally confidential. Public was not going to have access, access to them. And they ranged all the way from marriage applications, adoption records, all the way to the contents of grain elevators. And so we had to go through, and I had to draft a bill that amended each one of those sections, sometimes repealing a section because it didn't have anything to do with privacy, sometimes amending a section so that it complied with the constitutional balancing test. And I prepared two bills, one open meetings and one open records. Mike Greeley was given the task of sponsoring those bills, and he was a House member then, and so he introduced them, and they passed the House with no problem. When they got to the Senate, the adoptive parents group came out like gangbusters against this bill, and as a result, both bills died in the Senate in 1974. Mike Greeley, who was the recipient of the unintended consequences of these two bills, was running for the Senate that year, 1974, for the 75 session, and he was he was very popular in Cascade County. Everybody loved him. Family had been there forever, and he almost lost that race, primarily, I think, because of the adoptive parents' opposition to him because of the bill that he sponsored. In 1970, so I decided I would run for the legislature in 1974 after the second annual session, and when I got here in 1975, decided that I would put those bills back in. No, I would put the open records bill back in. I wasn't going to put the changes to the. I would put the open meetings bill back in. I wasn't going to put the changes to the Open Records Act back in. Pete and Harriet didn't raise any dummy, and I wasn't going to run through that one again. So we in 1975, we passed a bill that took out from the existing open meetings law those sections that really didn't have anything to do with privacy, and we didn't do anything with records, thinking, well, we'll let the courts deal with that. In 1977, because the old open meetings law really didn't work very well with the new constitutional provision, I drafted a bill that completely rewrote the open meetings law, and it is now, it was adopted then pretty much the way it is now. And one of the changes, why would the legislature mess with the self-executing provision? Because they could, I guess. And one of the things that we added to the statute was the definition of a meeting. A meeting is a convening of a constituent body of a quorum of the public body. Little did I know how that 50 years later would come back to haunt me. After the 1977 session, there were, I was involved, I was privileged to be involved actually in a number of cases before the Montana Supreme Court involving open meetings, involving whether or not a meeting should have been closed, whether or not a record should have been disclosed. And I have to tell you that over that period of time, our courts, under 4 different Chief Justices, Haswell, Gray, Turnage, and McGrath, have been really pretty generous, and their decisions have, with a few exceptions, been a positive enforcement of the provisions that you adopted. I want to talk just for a second about one of the failures which occurred, and I was going to, Governor Schweitzer kind of stole my story. He talked about the case that involved the case that occurred last year when the Montana legislature had one more member of their party on a committee such that they could have that person stay out and not have a quorum. So they would have a person stay out of their rump session, and they would have an open session, and they would go and they would have a caucus in private and kick the press out and not let the public in. And they would make decisions that affected the adoption of that bill, because they had, when they came back in, they had a majority of the committee who had participated in the caucus, although it was one less than a quorum. And so my argument to the Supreme Court was, the legislature can't adopt a provision that inhibits the right to know. The Constitutional Convention said this right to observe a deliberation is not conditioned upon whether or not a quorum exists. And in some cases, there will be meetings of public entities where public policy is decided, but no quorum exists. I didn't realize that in 1977, but the Montana Supreme Court thought otherwise and said, well, they didn't have a quorum. Open meetings law says there has to be a quorum or there's no meeting. So they continued to do that, and I assume that as long as the Republicans are able to have 2 more people on the committee than a quorum and drop one of them so they can have a caucus, they'll continue to do that. One of the only decisions of the Supreme Court that has been disappointing and hasn't really fleshed out the purposes of the right to know, which was designed to restore. When you adopted this, there was great mistrust of government, and the idea was that if one of the reasons there's mistrust is because we can't watch government decisions being made. You ended that, and I think over the 50 years that provision has been in effect, I think governmental trust in Montana has substantially improved. But we're now probably in a culture that is again mistrustful of government, and I'm afraid that unless we keep vigilant, the courts are going to start turning back. Your provision is solid, and as long as I'm around and able to help, I'm going to keep hammering away at it. I want to talk for just a second about the right to participate. No other state at the time, 1972, had a right to participate in their constitution. No other state. Don Foster, I don't know where Don Foster got this idea, probably from Rick Applegate, but he had this idea that the public really had a right to be involved in decision-making by government before a decision was made. So he introduced this proposal. It passed without much debate. When it came time to implement it, as Jerry said, it wasn't self-executing. The legislature could kind of flesh it out. When it was fleshed out, the only change really broadened it, because it said that it defined the kind of decisions that the public had a right to be involved in, and it was a very narrow definition, so that almost all decisions were subject to the right to participate. 8 years, it was 8 years after the Constitutional Convention was ratified, that a Constitution was ratified, that the court first had an open meetings case. And in that case, the court read Article 2, Section 8 and 9 together and said, essentially, it was a case where a county commission had a meeting on a subdivision, and then they didn't make any decision in that meeting, and instead they said, well, we'll talk about it later. A couple of days later, without notifying anybody, they just deliberated on the subdivision and approved it, and the school district was affected by this subdivision, sued them, and went to the Supreme Court, and the Supreme Court said, if you don't have notice, and that came right from the right to participate for the provision. If you don't have notice, a meeting is just as much closed as if you shut the door. That's a really significant provision, and over the past, 47 years that I've been doing this work, I would guess probably half of the cases that half of the complaints that people have about getting into a meeting have had to do with notice, failure to give notice. And in almost every case, we have been successful in convincing a court to set aside a decision or void a decision because of a failure of notice. And that's directly a result of Section 8, right to participate, and how the court reads the two together. Again, this is obviously my passion, and I guess as long as I'm standing, I'll keep after it. Thank you.
Thank you, Mike. Elizabeth will now discuss the interplay between the right of privacy and the right to know. Elizabeth?
Thank you. One thing that COVID taught us in the public school system is that the days of people not paying attention to what goes on in schools is probably over. Zoom meetings, as much as people can't stand them in some ways, brought a lot of people into participation mode with their schools. And it renewed that idea in a public school of how do we conduct our business mindful of the open meeting law, but also mindful of the equally strong and important right of privacy in the Montana Constitution. So I'm going to talk a little bit about how those laws actually work in practice. And I had no idea that Mike wrote most of the implementing statutes, so I'm going to find a way to work his name into my next oral argument somehow. It'll probably be derogatory, but I'll figure out something. So sections 8 and 9 of the Montana Constitution are the right to know and the right to participate. And as Mike indicated, courts read them together. There was a case out of Billings called Bryan versus the Yellowstone County School District, where the Billings School Board had closed 2 elementary schools, actually, due to declining enrollment. And even though they'd had numerous meetings and there had been a ton of public comment during those meetings, at their last meeting, the board reviewed information in a spreadsheet, a document that was not made available to the public prior to the meeting. That was the basis for, or part of the basis for, a complaint going forward to the Montana Supreme Court. And the court used that opportunity first to remind folks that committee meetings are subject to the open meeting law, as much as schools hated that concept. They are, and they always have been, and they probably always will be. But more importantly, they said it's impossible for the public to be able to exercise their right to participate under the Montana Constitution if they don't have the right to know. And that means that if you're going to be looking at documents or relying on information to make a decision, the public gets public notice, reasonable public notice of that information or those documents before you're allowed to, as a group, make that decision. Districts look at this differently throughout the state. The general rule, though, for meetings is that you have to have at least 48 hours notice. But all boards have school district policies that talk about the amount of that notice. The Bryan case made them go back and look at all of those policies and look at how they interacted with their community. And for any of you who have served on a school board or have been to a school board meeting, you know that unless we're firing a football coach, it's usually a pretty quiet room, and we don't have a lot of people show up. But again, COVID changed that, and the level of participation has brought more people into the discussion and the decision-making process with school districts, and that's a good thing. It can be cumbersome sometimes. It makes our meetings longer sometimes. But the level of interest in what's actually going on in schools with the school board is what was intended by the open meeting law, which is to open up the doors and let the public not only know what you're doing, but participate as required by law. We look at the implementing statutes in Montana and try to read them as liberally as possible, knowing that's likely how the school or the Supreme Court is going to interpret them. Mike talked about the definition of a meeting, and there was recently a case where the court did say it has to be a quorum of the constituent body. But there's also additional language in there that needs to be considered because it's important, and it makes our open meeting law so unique in a sense that it covers more than just the decision-making process. It's any time that a quorum of a constituent body is together to hear, act on, or discuss something that falls within its jurisdiction. So just because your group is not making a decision doesn't mean you haven't violated the open meeting law. If you're getting together and you're listening to information that the board can take action over, you've got a meeting. If you are going to be discussing it, whether you take action or not, your public has the right to be there. And schools do this monthly, sometimes for some unlucky schools, multiple times a month, frankly. And there are only a couple times that they don't have those meetings open to the public, and that's where that right of privacy comes in. There's 2 ways in Montana that a meeting can be closed to the public. The somewhat easy one is when we're talking about litigation strategy. So if your board or your public entity is in the middle of litigation and they want to close their meeting to talk to their attorney about litigation strategy, they can do so, and they can exclude the public, they can exclude the press. It doesn't work when there's 2 public entities suing one another. So it only works when you are a public entity being sued by a private individual or private entity. The most common way, though, that meetings are requested to be closed and where there is Some conflict sometimes and some real balancing on the part of the presiding officer is when there is an individual right of privacy that the presiding officer determines outweighs the public's right to know. Contrary to some popular opinions, it's not the entire board that makes this decision. It's the presiding officer by statute who has to make it. So particularly for entities that deal with confidential information all the time, like school boards do, it becomes an area where we do look to court decisions and we look to the competing right of privacy, which is Section 10 of the Montana Constitution, and read all those sections together. So realistically, how does this work? There's several different things that come before boards in Montana. And when we look at the issue of schools in particular, anything that has to do with a child and something that would be considered confidential, like an expulsion, a disciplinary hearing, an appeal of a grade issue or a placement issue, those are closed routinely and frankly without any dispute. The area where schools have to really balance and where you get the most interest is when we're talking about employee issues. If you look at the history of the cases in Montana, the Montana Supreme Court has consistently stated that public employees still retain a right of privacy in their performance. So when we're talking about performance evaluations of staff members, those will be held in a closed session. That might also mean that a grievance hearing pursuant to a collective bargaining agreement will be in a closed session. If we're not talking about a contract interpretation, but an issue related to an employee's performance, the board will likely close that meeting. Where this issue gets very murky, and less murky, frankly, as the number of cases come through, is when we're talking about public employee misconduct. And years ago, I'd say prior to 1996, it wasn't uncommon for public agencies or public entities, particularly schools, to close meetings that were at the board level that had to do with employee misconduct. One of the first cases came from the Whitefish School District, and if there's anyone here who is young enough to remember life before the internet, the internet wasn't popular, obviously, back in 1996. It was just coming into schools, and there was a teacher who had a computer on his desk, and he had the internet, and he was looking at porn pretty much all day, every day, it turns out, and was terminated for that. The public wanted to know why, but because of the nature of the issue, it was the school district's normal response is that we're not going to talk about it. We're not going to get into the facts of this. It's a public employee and termination, and we're going to maintain a right of privacy. It went to the district court, and the district court looked at this idea of what is the doctrine of public trust. And they related it back to this idea of the public has the right to know when individuals who are in positions of public trust engage in misconduct. Prior to this decision, this was an area or an idea that was applied to law enforcement officers, but hadn't been specifically applied to school district employees in Montana. Since that time, there has been a whole line of cases that have made it abundantly clear to any public employer, frankly, but particularly to law enforcement agencies and to school districts, that if you do hold a position of public trust, likely you are not going to have a right of privacy that exceeds the public's right to know. And that requires, again, the presiding officer to make that decision at the board meeting and to determine whether or not that meeting itself is going to be open and all those issues are going to be available for public consumption in that community. So those are the kinds of issues where we're balancing those particular very important constitutional rights and trying to implement that on a day-to-day basis in public schools. Andrew's going to talk, I think, also about how public records come into this, but that's also an issue in school districts and any agency, frankly, that maintains records. When you look at what the court requires with regard to public records, for a school in particular, almost everything is open to the public, short of the confidential personnel records that are performance related and student records that are protected by a federal law. Pretty much everything else, including how schools do their business, who they pay, when they pay them, all of that is open to the public pursuant to our Constitution and the way it's been interpreted. Schools make those decisions, again, based on the implementing statutes that came out of the constitutional provisions that we have in place. And while it's a balancing act, it does allow particularly parents in communities to get a great look to see how school districts make decisions that impact their kids. And with the invention of Zoom, we have more people paying attention. And it's been a great thing for schools. It's not always a popular law that has to be implemented in a school, particularly when boards are internally struggling themselves and they would like to close the doors and have it out amongst themselves. But that's not contemplated by the constitutional provisions. There's an expectation, again, you're a publicly elected official. So as a group, if you can't get it together, you're going to have to figure it out in public or do it with less than a quorum of you. And it works. It is sometimes cumbersome again, but it has, I think, truly made education better in Montana, and it's allowed parents to have a much greater understanding of how their kids are being educated and who's educating them. And it results in wonderful community-based education with our constitutionally vested trustees who are also part of the Montana Constitution. So for that, I would say thank you to everyone who took part in that, because it does work. It is sometimes tricky with regard to the rights of privacy and the right to know and the right to participate, but it has benefited not only just parents and communities, but I think it's benefited everyone in the state of Montana. Thanks.
Thank you very much, Elizabeth. Our final speaker today is Andrew Huff, and he's worked as a lawyer for the governor, and he's going to address handling requests for the production of documents or other disclosure as a governor's attorney. Andrew?
Thank you. So I went to law school in Boulder, Colorado. I'm a tribal member. I went there specifically to study Indian law. I wanted to represent tribes. So when you're studying Indian law, a lot of it is about just the issue of jurisdiction. What government has jurisdiction in what area of a reservation? And a lot of the law is basically about fights between tribes and states arguing over jurisdiction. So when you're a tribal sovereignty advocate and you're learning the area of federal Indian law, you sometimes don't have a very nuanced perception of state government. So as an Indian person graduating from the University of Colorado, intending to go represent tribes, my perception of state government was pretty one-dimensional. I thought state governments were huge, that they were kind of monolithic entities, that they had infinite resources, and that perhaps they had malign intentions of some sort or other. So it was very, it was not nuanced. It was not a developed understanding of state government. And so as I started my legal career, I continued to and did represent tribes. But in those early years, coming back to Montana, I also learned really for the first time about the Montana Constitution, because obviously in Colorado they didn't tell you about the Montana Constitution. So I learned as a young lawyer about some amazing things in the Montana Constitution, like the commitment to preserve the cultural integrity of American Indian people in the state's educational goals. That was something that I had never even thought possible to exist in state law, let alone a state's constitution. The right to a clean and healthful environment, and another right that I had no idea could actually exist in a state constitution. And of course, the three rights that we're talking about here, the right to participate, the right to know, and the right to privacy. As a young lawyer, I understood these three provisions to be kind of a central pillar of a healthy democracy. Because what they do is they ensure transparency in government operations. And because of that transparency, they ensure accountability. The voters can vote people in or out of government depending on what they're finding out about what the government is doing. So accountability is there. These provisions also put definite limits on government conduct. The right to privacy basically says we Montanans have an absolute right and fundamental right to privacy, and the government cannot infringe it absent some sort of compelling interest. So in my view, those three provisions were a central pillar of a healthy democracy, and they ensured here in Montana that the people were in control of the government and not the other way around. So I have always been very proud of coming from a state with such an amazing document governing the state government here in Helena and throughout the state. So I then went to work in state government. So from about 2006 to 2017 or so, I worked in state government. And I worked first in the governor's office on Indian policy issues, and then I went into the attorney general's office for several years and worked on a variety of issues. And then I went back into the governor's office as chief legal counsel. And during that 10-year period of time, I got, I think, a considerably broadened viewpoint of both state government and our sunshine laws. So with respect to state government, of course, my one-dimensional understanding as a law student I found was completely erroneous. I mean, I've looked at other state governments, I've worked with other states. The state government of Montana is not huge. It's relatively small compared to other states. It's not in any sense monolithic. It's basically a huge collection of different groups of people working on totally separate issues in different ways. The state government definitely doesn't have infinite resources. Generally, you find that people are working hard on incredibly difficult issues. They're understaffed, under-resourced, yet they do an incredibly effective job. State government is not at all, in my opinion, it cannot generally be said to be malign. So that was a complete mistake on my part. You know, I learned working in state government that it's full of Montana citizens working hard on incredibly difficult issues, you know, without a lot of resources. So my perception of state government, of course, totally changed. My understanding of the sunshine laws also changed quite a bit. And I still, to this day, of course, believe the right to participate, the right to know, the right to privacy do constitute a central pillar of our healthy democracy. And I think that's true now, today, even more than ever, that these things have to be understood in the most broad sense. Like Mike and others were saying, the courts in the state have generally construed those very broadly to support the idea of transparency and accountability, and to support the idea that it's the people in control of the government and not the other way around. But I also came to understand, working in state government, two things, specifically really with respect to the public records laws. The first one was that we have good public records laws, but in particular in the early 70s, there was something that didn't yet exist: electronic mail. And the law, the Constitution and the laws, in my view, haven't quite caught up yet. The state government of Montana has not shifted to account for the vast increase in electronic communications in state business. So, you know, your standard public employee in state government probably writes hundreds and hundreds of emails every week, and of course tens and thousands of emails over the course of several years, and over the course of a career, it can be an amazing body of work, and it's all written. Those are written records. So one lesson I learned is that state government, how it functions, the laws haven't quite caught up with the existence of this vastly increased body of public records. And so I'm speaking as an attorney circa 2013 to 2017. But I think it can still be said today that there really isn't a good mechanism in place for collecting public records that are in electronic form and getting them to people who request them in a timely way. The systems, in my view, just aren't there quite yet. The other lesson that I learned over the course of my 10 years in public service was that public records laws can, in fact, be misused and abused. And I did see that in my time in the governor's office, and I'll talk a little bit more about that. So in terms of electronic mail and electronic communications, electronic databases, these sorts of things, as I was saying, the communications are vast. They're all written records, and public employees in the governor's office all across state government, that's their main mechanism of doing work. They do work via email. They track their decisions using email. They discuss things using email. And emails are saved because they have to be saved to track your work, to go back, to decide who is assigned what. So generally speaking, there's a huge amount of emails, and generally speaking, they're all saved because you need to save them to get your work done. I knew that going in to state government work, and one of the things that I advised everybody in the governor's office was what I called the Billings Gazette rule. So this is the rule that says you have to write every single email as though it's going to appear on the front page of the Billings Gazette the next day. And I think a lot of the folks that I worked with did absorb that rule. Some, of course, did not quite absorb that rule. And I have to tell you, there were numerous occasions in which, communications did end up on the front page of the Billings Gazette. One of the things I do, it's interesting, I'm also a criminal defense lawyer, and I'm not drawing any parallel between that work and my work in the governor's office. But people tend to think when they're writing an electronic email or texting or making a Facebook post that no one ever will read that, and that it's entirely private, that exists in cyberspace somewhere, and that it's a completely secure communication. Unfortunately, I find myself in the criminal defense work frequently looking at the evidence of my clients' crimes in writing and wondering why they were documenting them so extensively on Facebook and other things. I think the same can be said with emails in government work. People never think their email is going to be the one that gets posted in the Billings Gazette the next Monday. But it does happen. And if you're working with a good crew, they know, and they're sophisticated enough to understand that you're professional in your email communications. So Billings Gazette rule was the first thing I advised my clients about. The next thing was kind of an unwritten rule, more of an understanding than a rule, which was you can't write anything in emails bad about me. So the reason everybody understood that is because eventually I'd be reading their emails pursuant to a records request. And to their credit, I never did find a bad email about myself in the thousands upon thousands upon thousands of emails that I reviewed getting ready to respond to a records request. So the reason that I had to read every single email and every single communication in response to a records request that covered hundreds or thousands or sometimes tens of thousands of emails is there is this right to privacy. It's a fundamental right. It's a right that all Montanans have. Also, frankly, state employees have it as well. But if you're in a position of public trust and so forth, that you're giving up some of your rights to privacy when you work as a state or public officer. But the state government works with the private information of Montana citizens, very sensitive information. There's people working on child abuse and neglect cases in DPHHS. There's committees looking at domestic violence fatalities, peeling back the facts on those sorts of things. There's tax records. There's all sorts of information that is highly, highly sensitive, and private, covered by the right to privacy. So in order to release any records pursuant to a public records request, a review has to be done to make sure we're not going to violate anybody's right to privacy or violate any statutes which designate information in those emails as confidential. So each and every public records request does require a review, and it's typically a legal review. In my experience as legal counsel in the governor's office, we would have meetings, I think it was annually or biannually, of other chief legal counsels with other governors in other states. And we would talk about the issues we were facing and so forth. And, you know, when I would be talking with, say, the chief legal counsel for the governor of Washington state, you would just be amazed at the fact that there was only me in my office and one assistant. And in addition to doing all the other things legal counsel does for the governor, I was also the guy who was responding to public records requests. So typically, in other offices, you'll have half a dozen lawyers or more, plus much larger staffs in the chief legal counsel office. And typically, a person had the specific and sole job of responding to public records requests. That's all they did, all day long. So, you know, the idea that it would just be me astonished some of my colleagues, and that goes back to what I've observed about Montana state government generally. You know, it gets a lot of work done with not very many people and with very few resources. And public records management and response is one of those things, particularly, at least in my era, in the governor's office. So the problem that presents itself with that is that you can get overwhelmed pretty quickly if the records requests come in too fast and furious. When I started out, you know, I immediately started receiving those records requests. And some of them were just individual Montanans seeking a limited amount of information. That was easy. You get that out the door. You can also forward that on to a state agency. They can respond to that. A lot of them were requests from the media. You know, there'd always be a hot topic, and there'd then be a request for email communications amongst governor's office staff about that topic. So those were also pretty typically easy to respond to because they were time limited and were about specific topics, and you could collect those and get them out the door. But then there were always kind of a third set of requests that were just enormous. They would ask for things that would, you know, really amount to thousands of pages of documents and emails covering years and years. And they could be really burdensome. And some of them, you know, were in good faith, but some of them really weren't. We'd have these meetings with other legal counsel in other states. And I didn't experience this in Montana so much, but there were, in other states, people who would hammer an agency or governor's office with public records requests with the specific intent to harass them or kind of slow down government operations, because everything has to shift to responding to those. And most of them, like in Montana, if you don't respond in a certain amount of time or you miss certain information or things like that, you can get sued, and there's attorney's fees and other things at issue. So there can be a bad faith effort to use those to gum up the works of government. Now, in Montana, I didn't really see that very much. Most people were making specific requests for a limited amount of information, and it was possible to respond to them. But even dealing with the good faith requests, it was a lot of work, and it slowed down the operations of the Office of Legal Counsel for sure, getting all those out the door. Those are kinds of issues that I think confront agencies generally. And I think the problem in Montana is there isn't yet a centralized way of doing all of these necessary steps in responding to public records requests more efficiently and rapidly. So I found myself on many an occasion working in the governor's office wishing that someone else would just handle these public records requests. And I think if I were to improve the system, what I would suggest to the legislature and to others is, especially with respect to, reviewing thousands of email communications, that there should be a centralized way of doing that, like in the Department of Administration, where records requests can be forwarded to a group of people, IT folks, who can first run the searches, and then there'd be a stable of 3 or 4 attorneys permanently there in Department of Administration to do the legal review. In other words, take it off the desk of the agency and government legal counsels and centralize it. And then, of course, once they had gone through those things, you could pitch back the communications that the admin people think are responsive to the chief legal counsels of those agencies for a final review, just to make sure that they agreed there wasn't anything in there that they thought couldn't go out under the law. So that would be my my suggestion for improving the system, and I think it would also increase transparency in the way it's supposed to, because it takes it away from the agency and puts it in a third-party agency like the Department of Administration. So I think that's all. Oh, in terms of open meetings, there's been quite a bit of talk about that today. And I think, I was listening to Mike and others today, and I think there is a weird crossing over between the right of participation and the right to know, and a lot of confusion about that in the law, which, for example, resulted in this Usher decision, which is this decision about the legislature kind of kicking off, having a side meeting that people were disinvited to. When I was in the governor's office, I had a much kind of more simple view. I thought, that the right to know meant just what it says: deliberations of public agencies, bodies, people can go to those. So in my view, what that meant was, it doesn't have to be a quorum, it didn't have to be a specific, it could be staff members and some other people talking about something, and if, a member of the media wanted to go to that, they could, unless there was some privacy issue where it had to be closed down. So that's that, but the right to participate is something else. It's when you do have a specifically constituted governing body that has an area where it makes decisions, and what the right to participate says is, before a final decision is made, you got to get the public's input. And so you got to have notice and all these other things. And I think the case law kind of crossed over those two things and mixed them together. And so I think now there's a lot of law going back and forth about quorums and so forth, which really makes it unnecessarily complex. So I think the Usher decision is one of those cases that crosses between right to participate and right to know in a way that I think led to a bad result. Thank you.
Thank you, Andrew. When we started this program, I was worried that we wouldn't use up half the time. We have 3 minutes left. We could take one question, I think. Yes, sir. Could you use some mic? I'm wearing my earphones, but I can't hear you.
I'm sorry. We talked about this a little earlier, and I commend you for an outstanding presentation. It's a very good panel overall. Sometimes with all of the instances we've had of school shootings and other things, there's a issue of the public's right to know, which is very important. And at the other side, they have people who have things like mental illness and other problems where they try to stay out of the limelight. And that's an issue that we, as a society, we haven't really focused on sufficiently, because people have a right to know if somebody's a danger. But on the other hand, the person who is being treated, say, in a mental institution or something, has to have a certain amount of privacy to be able to overcome their illness. And mental illness is a physically based illness that can disable the ability of a person to function as a person. It requires medication. And we closed our medical institutions because we didn't have any basis for dealing with these people and how to deal with these things. And so this issue is a paramount issue for us, and not only in Montana, but for the nation as a whole.
Okay. Your issue may be outside these two issues we discussed today. I think the answer may be with regard to patients. I think a healthcare provider has an obligation to disclose when a threat focuses on a particular person. But I've been a long time since I've been involved in the law, and I'll see if there's something more up to date on the panel here. Does anybody wish to add something? If not, okay. I think we'll take announcements. And I'd like you to give our four panelists another round of applause.
Well, that was an excellent discussion today. Just a reminder, we will get started again in the morning at 9 a.m. With remarks by Chief Justice Mike McGrath. And now I want to call Molly Kruckenberg, the Director of Montana Historical Society, up for a quick announcement.
Good afternoon, and thank you. As you said, my name is Molly Kruckenberg. I'm the director of the Montana Historical Society. It's been truly inspiring to hear all of your panelists today speak about our landmark Constitution. Listening to your story, I hear themes of collaboration, leadership, forethought, and commitment. The delegates, staff, and supporters of the Constitution created a truly historic document, and we are grateful for your work. So in celebration of that work, I'd like to invite you to join us now at the Montana Historical Society for a reception. We're located directly to the east across Roberts Street. So please join us for drinks and conversation, and I hope to see you there. Thank you.